This is my statement I had prepared to give before the hearing on charges of conspiracy to treason and incitement that took place this morning, Thursday, January 14, 2021, but was prevented from giving. My respects to the panel of judges, Presiding Judge Ros Pisith, Judge Koeurt Sang, and Judge Im Vannak, acting in your respective role. My respect to the Deputy Prosecutor Seng Heang, who is extremely busy for such a young man, if I am to judge by the countless court warrants and summonses loudly bearing your name issued against innocent political activists and supporters. Instead of prosecuting us, we should be prosecuting you for the grave injustices and untold misery you have inflicted against innocent people. The detainees and their wives, husbands, sons, and daughters, whose lives and livelihoods are greatly disrupted. In presiding over this sham trial, a legal drama scripted by politicians, you are not only perpetrating a bitter injustice on those of us illegally charged, but you are also taking away valuable court resources from genuine complainants and plaintiffs and crowding jail cells which are already filled beyond their maximum capacity. Despite these injustices perpetrated against me and others, as a Christian, I forgive you. I only pray God may also forgive you as well. My respects to Clerk D. Lila, who has been my point of contact since the November 26th hearing. My respects to the court-appointed lawyers, also willing actors in this political theater. My respects to those wrongly charged with me. You are my heroes, and the lawyers genuinely defending their interests, your interests. My respects to the diplomats, to UN officials, to human rights monitors. Thank you for attending this political theater to help cast light on the darkness. In my defense, I will be referring to the 4 principal laws of Cambodia that are relevant to this case. The first is the Criminal Code. The second is the Criminal Procedural Code. The third is the International Covenant on Civil and Political Rights, to which Cambodia is a state party and the Constitution acknowledges as part of Cambodian law, which I will from now on refer to simply as the Law on Civil and Political Rights. And the fourth is the Constitution. As at the November 26th Thanksgiving Day hearing, Presiding Judge Ros Pisith acknowledged and permitted my request to self-represent as long as I attended all the court hearings, which I assured him I would do. This is the correct interpretation of the law. The right to counsel and the right to self-representation are complementary fundamental rights belonging to the defendant. Here, the charged person, me, enshrined to protect my interests as the charged person and the overall interests of justice. Specifically, the right to self-representation is guaranteed under Article 14, 3D of the Law on Civil and Political Rights. Of course, the right of self-representation is not an absolute right and can be curbed for the interests of the charged person and of justice. For example, in cases involving minor children, mentally incapacitated persons, or where the charged person is not present in court. Article 301 of the Criminal Procedural Code further provides that a lawyer is required in all felony cases. But here, I am 1, an adult, 2, not mentally incapacitated, 3, able and willing to attend all court hearings, and 4, a trained lawyer from one of the top law schools in the world who was probably the first person of Cambodian descent to pass the New York bar exam. I am both able and qualified to represent myself in this case, and I do not need to take rare resources, qualified lawyers, away from those who actually need them, the poor of Cambodia, when they are faced with criminal charges. In the interest of justice and in the interest of the charged person, me, for whom the law was enshrined to protect, I thank the court for acknowledging this right to self-representation. I will continue to insist on exercising this right, that is, to have no local lawyer except at the moment of arrest, should that happen. Even if I have top-notch international counsel, Jared Genzer and his amazing team at Perseus Strategies based in Washington, D.C. Unfortunately, the COVID-19 virus and politics make it difficult for Jared to attend this hearing. As it is established that I have a right to self-representation, all legal provisions relating to my legal defense must be read to accommodate and facilitate this right to representation, including, in particular, Article 129 of the Criminal Procedural Code, which provides lawyers access to case files. In short, the right to represent myself is meaningless if I cannot access my case file and receive all the necessary documents to put forth a proper defense. However, I have been given only 3 sets of documents on 1 December 2020. 1, the prosecutor's introductory submission, 3 pages, dated 9 September 2019. 2, the prosecutor's final submission, dated August 2020. And 3, the investigating judge's closing order, dated August 2020. Despite making repeated in-person requests, I was refused access to 7 additional documents listed in the final submission and the closing order. 1, the prosecutor's criminal case file number 605, which is my case, but I have no idea what they had created out of thin air. Dated September 2, 2019. 2, the Phnom Penh Municipal Court's investigation case file number 4154, dated September 2019. 3, these are the documents I am requesting because they relate to my case file and they're mentioned in the final submission of the prosecutors and the closing order of the investigating judge, and the closing order forms the basis for the trial hearing. So 3, the investigating judge's letter to inform of the closing of investigation, dated July 2020. 4. Order requesting review of case file dated July 2020. 5. Report of the Internal Security Department of the Ministry of Interior dated September 2019. 6. The summons for me to appear dated November 6, 2019, mentioned in the investigating judge's closing order, the indictment. And 7, cancellation order of this summons to appear dated November 15, 2019, mentioned in the prosecutor's final submission to the investigating judge. I am charged along with 45 other individuals in my case, but then in court this morning I found out there's another case that has been included in this trial hearing involving the CNRP leaders, and there are some dozens, a dozen of them or so. I am charged along with 45 other individuals plus the other case involving CNRP leadership, present and exiled, for conspiracy to commit treason and incitement to create social disorder. As my liberty and the liberty of the others are at stake, we each face up to 12 years of detention, a total of 552 years for 46 individuals. But there are 130 individuals, now times 12. Years in prison, wasting state resources, taking space from real criminals in an already crowded detention centers. In prisons that are considered to be medieval, extremely overcrowded, and lacking basic humanitarian standards. It is necessary not only that I have access to these 7 requested documents, but also to any other documents held by the police, prosecutor, or any government agency that relate in any way to charges against me. From the very beginning of these proceedings, this regime has violated my due process rights. Under the law of civil and political rights, a law of Cambodia, I have the right to be informed promptly of the nature and cause of the charges against me. This includes both the law and the facts on which the charges are based. However, I have been denied the latter information. None of the documents that the regime provided to me before this hearing have identified or have reported on any specific action I took that were allegedly criminal. Rather, the documents simply allege in a conclusory manner, without providing any single specific example, that I used the internet to appeal to the Cambodian people and the armed forces and the armed services to act against this regime. In short, given these documents were required to disclose any and all evidence that will be presented against me in this proceeding, and instead included unsubstantiated and vague allegations, the court should immediately dismiss the charges. I also have the right under Cambodian law, the law on civil and political rights, to have adequate time and facilities to prepare my defense. However, without knowing the factual basis of the charges against me, I have been unable to prepare any defense whatsoever. If any new factual allegations are presented against me today, this trial must be immediately adjourned and postponed, as I will have had no time to discuss them with counsel, conduct legal research, or gather evidence rebutting the charges. The regime has also violated my right under the law on civil and political rights to examine the witnesses against me and obtain the attendance and examination of witnesses I might present on my behalf. I could not be prepared to cross-examine witnesses today that I knew nothing about, nor could I identify and prepare witnesses for my defense without knowing what factual assertions I needed to rebut or disprove. For example, I am puzzled over the summons for me to appear and its cancellation order allegedly issued for me in November 2019. Shouldn't the investigating judge's closing order, the indictment, include the information in the prosecutor's final submission on this matter? But how is it that the final submission of the prosecutor to the investigating judge, how is it that the final submission mentions once and only the cancellation order of the summons to appear, the cancellation order, dated 15 November 2019, and the closing order, a later dated document forming the basis for this trial hearing, mentions once and only the summons to appear, dated November 6, 2019. For your information, on November 6, 2019, I was in Tromsø, Norway, for a human rights seminar hosted by the Norwegian Ministry of Foreign Affairs. I departed Cambodia at midnight on 2 November 2019 and arrived back into the country on 9 November 2019. Prior to departing for the high-level seminar in Norway, I posted publicly on Facebook and on my personal website daily and multiple times a day. During the journey and during the seminar, I posted publicly on Facebook and my personal website daily and multiple times. After the seminar, while traveling back and inside Cambodia, I posted publicly on Facebook and my personal website. I knew nothing of any summons to appear and its subsequent cancellation of November 2019. The first time I heard about these absurd charges of treason and incitement was on November 6, 2020, and the next day received the summons to appear just a little more than 2 months ago. Finally, under the law on civil and political rights, in the determination of any criminal charge against me, I have the right to a fair and public hearing by a competent, independent, and impartial tribunal established by law. As noted before, there has been no specific evidence provided to me by the court, prosecutor, or any other authority to support the charges being brought against me today. I was entitled to receive any and all such evidence in advance of the trial hearing to enable me to adequately prepare a defense, to prepare to cross-examine prosecution witnesses, and to identify and prepare witnesses that I would offer in my own defense. As such, if these charges against me are not immediately and and summarily dismissed, and with prejudice, then it will be clear that either this panel of judges is incompetent or that it has acted in a manner that is not independent or impartial. It goes against the grain of reason and the principles of justice that Article 256 of the Criminal Procedural Code can erase all small and gross violations alike just because the closing order has become finalized and definitive. The closing order is dated August 26, 2020. I was first informed of the charges against me on 6 November 2020. I am charged, along with these 45 other individuals, and now more because of another case grouped together with us. We are charged with a conspiracy to commit treason and incitement to create social disorder. These charges are absurd, and they would be laughable if not for the very serious consequences to our lives and to this country. In Khmer, treason is composed of two words, very clear and straightforward. Bot, cheat. Bot, betray, cheat, nation. I do believe treason has been committed, but not by me, nor by any of the charged persons with me. You are focusing on the wrong people. May I give you some leads on the real perpetrators? The link to my personal website, which details the occupation of Vietnam and Hun Sen's relationship with Vietnam, and now the elephant in the room, China, and Hun Sen's relationship with China in Cambodia. Incitement to create social disorder. There is a very real distinction between peaceful protest, political dissent, and incitement to violence. I am a strong believer in and a practitioner of peaceful protest and political dissent. And I have seen nothing in the 3 sets of documents I received to think that the others charged with me have perpetrated treason or incitement. What I see instead is protected political speech and opinion. Indeed, Article 19 of the Law on Civil and Political Rights not only shall everyone have access to have the right to hold opinions without interference, but everyone shall have the right to freedom of expression, which includes freedom to seek, freedom to receive, freedom to impart information and ideas of all kinds, regardless of barriers and frontiers, either orally, in writing, or in print, in the form of art, or through any other media of his or her choice, which includes the internet. If you want to see a real case of incitement, may I ask you to look at the recent events in Washington, D.C. Protected political speech. The real purpose of the charges against me is to silence me, as I have been a long-standing and outspoken critic of Mr. Hun Sen and his party. But both under the Constitution of Cambodia and international law, which has been incorporated in Cambodia legal system, I have the right to freedom of opinion and expression, which includes the right to express dissent, criticize the government and its leaders, advocate for peaceful change of government, and share political opinions. In fact, international law provides a particularly high level of protection to uninhibited expression in the context of public debate concerning figures in the public and political domain. In 2015, the UN Human Rights Committee demanded that Cambodia, quote, refrain from prosecuting journalists, human rights defenders, and other civil society leaders as a means of deterring or discouraging them from freely expressing their opinions. Unfortunately, the charges against me demonstrate that the government or this regime has failed to take these words to heart. Concluding remarks. My documentary birthday is 10 November 1973, but in reality, I am turning 50 this month. Today could be my birthday. Should you decide to go through with your injustice in jailing me and the other innocent people, I welcome this birthday injustice with good humor and with offer of forgiveness. The Deputy Prosecutor Seng Heang speaks about his concern for those charged and asks that the cases be grouped together to ease the administration of justice for those charged as they live in far-flung provinces and the costs, including travel and accommodation, are burdensome. I agree. Thus, may I ask that the court drop all these absurd charges without any basis in fact or in law. If anyone is to be jailed for political opinion or political expression, a fundamental protected right in a democracy, it should be me and me alone. As all my adult life, I have advocated for this fundamental right and other associated democratic rights and have trained other people on them, possibly including many people charged here. Moreover, my co-defendants have families to care for, whereas I only have a dog. For example, Heng Chan-Soti, who is currently in pre-trial detention, has 5 children. They need their father. The law requires that all these charges be dropped unconditionally. But if you do not respect the law, then out of humanitarian concerns, release all political prisoners and drop all these silly, baseless, absurd charges without conditions. I wish you a happy new year. Thank you.